Judicial System of England. Introduction. In England, justice is available to all people, whether they are rich or poor. This is due to the independence of the judiciary and the rule of law. When we talk about the judicial functions of the British Parliament, we mean the judicial functions of the House of Lords. The rights and liberty of every individual are protected by the judiciary in England. Salient features. The following are the salient features of the British judicial system. A. Rule of law. The rule of law is an outstanding feature of the British judicial system. It means that none of the persons is above or below the law, and all persons are equal in the eyes of the law. Courts will apply the same law on all subjects. B. Speedy justice. Speedy justice is another feature of the UK judicial system. Cases are disposed of quickly. It is because judges possess greater discretion, carefulness or judgment, in dealing with legal technicalities, and judicial rules of procedure are made by a special rule committee. C. Independence of the judiciary. The courts of the UK are free from all the pressures and decide the cases on merits. D. Neutrality. The courts are neutral in the UK, and they never support any party, plaintiff or defendant. The courts complete the requirements of justice in a neutral manner. E. Equality. The courts in the UK represent the principle of equality. It is the duty of the prosecution to prove its case beyond a reasonable doubt and on its own merits. F. Jury system. The jury system is another unique feature of the British judiciary. In all serious criminal cases, the accused must be tried not by a judge alone but also by a jury, which is a group of laymen who are appointed to assist the judges in the administration of justice. In all civil cases involving an accusation against the moral character of either of the parties, that party may demand a verdict decision by a jury. G. Dual system of bar. In the UK, the lawyers are divided into two parties: the solicitors and the barristers. While the solicitors deal with the clients and prepare cases, it is the barristers who argue them in court. H. No judicial review. Courts in England have no powers of judicial review. On account of the sovereignty of Parliament, the institution of judicial review does not exist in England. No court of law can declare ultra vires a law passed by the British Parliament on account of its unconstitutionality. The organisation of courts in England. The courts in England are divided into two branches, the civil courts and the criminal courts. Comprehensive details on the subject matter are listed below. A. Civil courts. Civil courts deal with private law or disputes between one citizen and another. The organisation of the civil courts in England is reflected below. 1. County courts. At the bottom of the civil courts is the county court. The whole country is divided into about 337 counties, and each county has a court. A county court has one or more circuit judges, assigned by the Lord Chancellor. 2. High Court of Justice. It is located in London. It is an appellate court against the decisions of county courts. The cases that don't fall under the jurisdiction of county courts are referred to the High Court of Justice. The High Court of Justice, also known as the Supreme Court of Judicature, is divided into three divisions. A. Queen's Bench Division. The Queen's Bench Division deals with ordinary civil cases. B. Chancery Division. The Chancery deals with cases of equity. C. Probate, Divorce, and Admiralty Division. This division deals with cases of marriage, wills, and ships. 3. House of Lords. The House of Lords is the highest court of appeals in civil matters. It consists of 10 Lords of Appeal in ordinary. 4. Court of Appeal. Appeals from county courts and the three divisions of the High Courts of Justice lie with the Court of Appeal. The presiding judge is called the Master of the Roll. It consists of 14 Lord Justices of Appeal, a Lord Chancellor, and all 3 presidents of the Bench Division of the High Court of Justice. B. Criminal Courts. Criminal courts deal with branches of public law. The organization of criminal courts are distributed as follows. 1. Justice of Peace and Stipendiary Magistrates. At the lowest level of the criminal courts is the Justice of the Peace and Stipendiary Magistrate. The honorary judges are appointed in the various localities to decide criminal cases of a petty nature. These judges are called Justices of the Peace. 2. The Court of Assizes. These are the local courts to try criminal cases and are branches of the High Court. Cases in these courts are heard by a judge and a jury. The president of this court is a judge of the High Court. This court is conducted in each county twice a year. It has jurisdiction over various heinous offenses, such as imprisonment or death. 3. The Quarter Session Courts. This court consists of all the justices of the peace in a county. All the justices may or may not participate in a session of this court, but 2 justices are necessary to constitute a quorum. Cases involving death sentences or other very serious cases are not headed by this court. 4. Courts of Criminal Appeal. Appeals from the Quarter Session and Assizes lie with the Court of Criminal Appeal. This court consists of the Lord Chief Justice and the judges of the Queen's Bench. 3 general judges heard the appeal. 5. Judicial Committee of the Privy Council. It reviews cases referred to it by various British colonies. In fact, it does not decide cases but gives advice to the King,